The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone, and welcome to today's webinar, 5 Questions Employers Should Ask Every Year. Before we get started, I'd like to go over a few items so you all know how to participate in today's event. You do have 2 audio options to choose from, computer audio or by calling in via the phone. To switch between the two, just click on the circle next to your preferred audio option in the audio section of your control panel. You will also have the opportunity to submit text questions to today's presenters by typing your question into the questions pane of your control panel. You may send in questions at any time during the presentation. We will collect these and address them during the Q&A session at the end of today's presentation. Our speakers today are David Stevens and Caitlin Brady, attorneys at Whitford, Taylor, and Preston. And now,
well, hello everyone. Hello everyone. Thank you for joining us this afternoon. As Ryan said, my name is David Stevens, and I'm joined today by Caitlin Brady. We're attorneys in the Labor and Employment Group here at Whitford, Taylor, and Preston. I'm based in the firm's Baltimore office, and Caitlin is based out of our Washington, D.C. location. Our intention with this webinar is to give you an overview of some key areas where employers often run into problems, and in particular, areas where problems can arise due to changes over time. Employment law is one area where changes have really become routine, in part because new statutes and regulations can come from either the federal, state, or even the local level. And beyond simply changes to the laws themselves, changes in your workforce or the particular jobs your employees are performing can also lead to a need to update your contracts and policies. So we decided to position this session near the beginning of the year because the topics we're going to be talking about are really things that should be looked at on a periodic basis in order to ensure that your company is up to date in how they're managing their employees. So as we get started, one preliminary note is that as you're going to hear, a lot of the laws and issues that we're going to be talking about are really not one-size-fits-all issues. So while we're going to be going over some general information, how a law applies to a particular employee or in a particular situation will really depend on the individual circumstances of the employer. So we would certainly strongly recommend that you engage counsel and seek out legal advice when making any decisions regarding particular issues that you may be confronting. So with that said, let's jump in. So the first item we're going to be talking about today is the employee handbook. And for just about any size of employer, this is an important document to have, as it really serves as the core statement of your policies and your expectations for your employees. So really what we want to start out with as we talk about this today is some basic considerations to keep in mind when you're thinking about, whether your handbook is up to date and whether it has the provisions that you really need. So really, there are 3 kind of basic questions that I would break this down into. The first question is, does my handbook contain what I would call the foundational handbook provisions? The contents of an employee handbook can really vary significantly from company to company. Some may be 20 pages, some may be 80 pages, and a lot of the content will differ based on the specific policies that a company has in place. But there are certain provisions that you would expect to see in basically every employee handbook. And I've listed 2 here as examples. I'll touch on the anti-harassment issue first. That's really a critical policy, not only from the standpoint of setting your expectations as to how you want your employees to treat one another, but also from the standpoint of defending against potential claims, which can be, really a benefit to having this in your handbook. Back in 1998, the Supreme Court issued 2 decisions in which they held that in a scenario where an employee makes a claim of harassment based on a coworker's conduct, an employer may be able to establish a defense to that claim if it can show that it had a procedure in place to prevent harassment and the employee who's making the complaint unreasonably failed to take advantage of that procedure. And so the anti-harassment policy in a handbook can serve as the foundation for demonstrating that the employer had that type of procedure in place. Now, the ideal is to go beyond a simple statement that harassment won't be tolerated, but to also identify a process for reporting complaints and a statement that complaints will be investigated and that the company won't permit retaliation against employees who report misconduct in good faith. So that's one example of a policy that we would really expect to be present in a handbook, really regardless of what kind of business the company is in, whether it has 20 employees or 2,000 employees. The other example we've listed here is the at-will disclaimer, meaning language that makes clear that the handbook is not altering the relationship of at-will employment between the company and the employee. That type of provision is critical in avoiding a scenario where the company seeks to end the employment relationship and the employee then points to some provision of the handbook and essentially argues, well, based on this policy, that limits the circumstances in which I can be let go. And that really ties directly into the second question that I have here, which is, does the handbook avoid language that could be construed as unlawful, or is it imposing policies or obligations that you don't really intend to undertake? So it's sort of the flip side of, do I have everything in there that needs to be in there? You're also asking, do I have anything in there that really shouldn't be in there? And just to sort of tie that back to the at-will disclaimer, you'll sometimes see in a handbook what's called a progressive discipline policy, which would say something along the lines of, well, in the first instance of misconduct, the employer, will issue an oral warning, then a written warning, then a suspension, and then a termination. And so it's important when you're looking at that to see, well, have I also kind of clarified that the employer's maintaining the discretion to skip certain steps or to, terminate the employee if there's, really egregious misconduct, so that you're not looking at a scenario where, the employee has done something that you think is a basis to terminate them, but you've got a policy sitting there that says, well, in order to terminate you, we're going to go through these, 3 or 4 steps first. So that's why it's important to pair that with some at-will disclaimer language. And then sort of the third question that I've got here is, does the handbook accurately reflect the company's policies and experience? Certainly, you often have handbooks that can become out of date in terms of the last time we looked at it was 10 years ago. Since then, the company's changed its holiday schedule or it's changed some other policy. And so now the handbook doesn't really track with how things are actually being done. And you don't want to create that discrepancy between what you're actually doing in practice and what you've got, written down on paper. So those are really some core concepts to have in mind when you're thinking about your handbook. But before moving on, I just want to touch on a couple other reasons why it's important to be looking at your handbook at regular intervals. The first consideration there is, am I up to date on any new statutes or ordinances? As I said at the outset, those are coming out pretty frequently these days. For anybody we have on the line from Maryland, I'm sure you're familiar with the paid sick leave statute that came out just about a year ago now, which really forced many employers to alter the way they were handling paid time off. So that's kind of a basic issue. You want to make sure that if there have been changes in the law, that you're updating your handbook as things go along so that you're not falling out of compliance. And then the second issue there is, am I operating consistent with the laws in any new jurisdictions where I'm now operating? So for instance, if the company has opened a new office in a new state, you want to make sure that you've taken a look to say, okay, well, at least for the employees in that new state, are we operating in a manner consistent with what the laws there require? Because you often have differences from things that are as simple as, how often do I have to issue paychecks? Is there a law in this state that says you have to pay every week or every 2 weeks? To things that are as complex as, is there a different paid sick leave law that applies there that's really not consistent with sort of the core policy that I've been applying in terms of PTO for my other employees. And then a final point that I just wanted to note in terms of why it's important to update your handbook periodically is, oftentimes, and I think it's fair to say that this is a relatively new development, there will be laws that actually come right out and say that as part of the process for giving notice to employees of the rights that those statutes are creating, the employer is directed to include certain notices in their employee handbooks. And so I've given one example here from a Maryland statute where back, I believe it was around 2013, there was an update to Maryland's anti-discrimination law that essentially said that employers were going to be obligated to consider certain types of accommodations for employees who become disabled as a result of a pregnancy. And as part of that law, which you can see in the language here, the statute actually directs employers to include in any employee handbook that they have information concerning the employee's rights under that particular law. So that's just some ideas to keep in mind as to what to look out for when you're considering your employee handbook and whether it's up to date given any recent developments, both sort of external in terms of legal changes and then also internal based on developments within your company. So we'll go ahead and move on to the second of our big questions for the day, and that is, do I have restrictive covenants for my key employees, and are they enforceable? So what are we really talking about here? Well, there's different types of post-employment restrictions that employers will consider using with regard to their employees. There's the non-disclosure agreement, which essentially calls for the employee to keep certain information confidential that they learn during the course of their employment. There are non-solicitation agreements where the employee is agreeing that for a certain period of time after the employment ends, he or she won't solicit the employer's customers and or attempt to hire away other employees. And then there are non-competition agreements which state that the employee will not work in a position that competes with the employer for a certain period of time after the employment ends. And then the last bullet there is sort of a related issue that you often see worked into these restrictive covenant agreements, which are essentially provisions that deal with intellectual property in terms of making clear that anything that the employee creates in the course of their work is going to be property of the employer, and that they aren't having any property rights in whatever work product they've generated in the course of their employment. Now, the main concept to keep in mind with regard to these post-employment restrictions is that they're treated by courts in a different way than a normal contract. Normally, when a court looks at a contract that someone is trying to enforce, they're principally looking at, well, what does the contract actually say, and enforcing it based on the intention of the parties that's reflected in the contract itself. With restrictive covenants, however, courts will look beyond the language of the agreement itself and will assess whether the contract is reasonable in the particular circumstances. So for that reason, these contracts are generally not one-size-fits-all documents, because a court will be looking to see whether, in the circumstances at issue, the covenant's reasonable in terms of what it's restricting the employee from doing, how long it's in effect, and how broad of an area it applies in. So when using these type of agreements, it's important to keep in mind that if an attempt is made to enforce them, they will be subject to that kind of analysis. So you want to ask yourself, is this overbroad in a way that may cause a court to decide, this is just too big an agreement, we're not going to enforce it. The other thing to keep in mind is that where the employee is and what state's law is going to control the analysis is very significant in evaluating whether or not an agreement's likely to be enforced. Different states take very different views of what types of restrictions will be enforceable. Many states use a reasonableness test that sort of gets developed over time as new cases get decided. Other states have statutes that specify what types of restrictions will or won't be enforced, and other states simply refuse to enforce certain covenants in just about any circumstance. So it's important to keep in mind, where my employees are, where litigation would happen if we were to attempt to enforce the agreement, and sort of consider that when you're evaluating, do I have the covenants in place that I really believe that I need? One final issue just to keep in mind in terms of thinking about covenants not to compete and whether you've got in place what you need is that over time, the standard under which a court looks at these can change. As I said, in a number of states, the way these get looked at is, a court will look to how have similar restrictions been applied in the past, what have prior cases said about, what's reasonable and what's not reasonable. And so occasionally you will have an agreement that, may have been enforceable, at some point in the past, that if it were to be looked at now, a court may have, greater reservations about. And the example that I've put in here is some language from a Virginia decision that came out about 8 years ago now, where the court was looking at an agreement that an employer was using, and that agreement actually was identical to an agreement that the court had looked at in the past and said was enforceable. And yet the court, looking at it in 2011, essentially said, well, yes, we acknowledge that this is the same language that we have previously enforced, but given the case law as it's developed over time, what was enforceable in 1989 is no longer enforceable in 2011. So, not every situation is going to be like that, but again, that's just an example of, the need to sort of not put this in a drawer and not think about it for 20 years. You do want to periodically consider, is this meeting my needs? Are we comfortable with what these documents are providing? So that brings us to our next topic, and I'm going to turn it over to Caitlin to walk you through that.
Good afternoon, everyone. So the third question that we'll be covering today is, are my exempt employees really exempt? And this question governs the exempt status or non-exempt status under the Fair Labor Standards Act or the FLSA. And exemptions are construed narrowly. Courts have specifically said that, and it's very important that employers review their employees' status under the FLSA to ensure proper classification. Exempt status or non-exempt status can be the determination as to whether the employee is eligible or receives overtime pay or the minimum requirements of minimum wage under the FLSA. So there is a lot of common misconceptions about exempt status under the FLSA. One of the most common misconceptions is that the employee is exempt if he or she is paid a salary. This is incorrect, and there are many considerations and factors that go into whether or not an employee is in fact exempt and is exempt from the requirements under the FLSA. The FLSA specifically sets forth various different exemptions, as well as state and local law as well. But for the most common exemptions, employees will qualify only if they are paid on a salary basis, which I'll explain in the next slide, and if they satisfy the duties test of the specific exemption in which they believe they are exempt. So one example of an exemption from the FLSA or an exempt employee is called the executive exemption. Again, so under this exemption, there has to be, the first part of the test is the salary basis requirement, meaning that the employee is paid on a salary basis. That specifically means that paid on a salary basis means that the employee receives a predetermined amount of compensation every work week that is not reduced or determined based on the quality or quantity of work, meaning that in any work week in which the employee works, they are permitted to receive that predetermined amount of compensation. There are some minor circumstances in which that situation changes, but for the most part, if they are working in any week, the employee must receive that predetermined amount. In addition to how and when they are paid under the salary basis test, the FLSA also requires that as of currently, the employee receive at least $455 per week. And as in the last few years, there has been many regulations and requests to change this amount, and I'm sure that this will be an issue that is again brought up this year. In addition to the salary basis test, there is also a test that the employee must satisfy the specific duties. Under the executive exemption, the duties are that the primary duty of the employee is the management of the enterprise or a division of that enterprise. So let's break that down. Primary duty is the main duty, the major or the most important duty that that employee performs for the employer. Managerial duties, meaning that the employee is involved in, its main duties involved in interviewing or supervising, training, discipline, has some kind of managerial aspect as his primary duty and role in the company. The next factor is that that employee regularly and customarily directs the work of at least 2 or more full-time employees. Again, this complements the managerial aspect factor that the employee is acting in almost a supervisory role over at least 2 full-time employees. And the last factor that is considered under this exemption is that the employee must have the authority to hire or fire employees, or to make the authority to make recommendations that are given at a particular weight. And particular weight means that the employee's recommendations for hiring or firing or disciplining the supervising employees is taken with substantial weight or in major consideration of making a determination. If all of these factors are satisfied, the employee falls under the executive exemption and is exempt from the FLSA's requirements. So again, the next example of an exemption is the administrative exemption. Similarly to the executive exemption, this involves the salary requirement, again, a predetermined amount of compensation that is not reduced based on the quantity or quality of work performed. A similar amount of the $455 per week is required. Once they satisfy that, the next question is whether they satisfy the duties test. Under the administrative exemption, there is the primary duty of the employee must be to perform office or non-manual work, which is related to the running or servicing of the business or the business operations. This is important. It can't be, this is contrasting to someone working a production line or doing the manual labor. This employee who's under the administrative exemption is someone who has the integral part of working directly assisting the running of the business. Some examples are HR, accounting, marketing, working with the direct servicing and running of the business. The second factor under the duties test that they must satisfy in this to be an administrative exempt employee is that their primary duty involves the exercise of discretion and also exercising independent judgment. And the FLSA specifically states that those exercises of judgment and discretion must relate to matters of significance. So this means that the employee must have the independence to make a free choice without the immediate supervision, and have the ability to formulate, change, implement management policies, and have the ability to make its own decisions and exercise its judgment in performing its roles. The matters of significance part of this specifically refers to that the employee can't have its discretion or independent judgment with minor tasks or everyday tasks. The FLSA really carved out this exemption for employees who have significant dealings and have are able to exercise judgment with levels of importance and consequence of their work, and have some kind of impact on the running of the company. In addition to these two examples, again, there are various other exemptions. These are just two examples of which are under the FLSA. With that said, the FLSA sets forth the minimum standards for minimum wage, for overtime pay, for various things, but it's also very important to look at your local and state laws and ordinances specifically to see whether there are higher requirements regarding minimum wage or overtime, or specifically to see if that state or your local area recognizes the exemption on which you're relying on. It's always important to consult and see if all the local laws and ordinances are applicable to your specific situation. And all right. And that leads us into our next, the fourth question of today, which is in line with that, is whether your employee is an independent contractor, if it really is an independent contractor. So in addition to evaluating whether your employee is an exempt or non-exempt, it's also very critical and important for an employer or a business to determine whether individuals working for them are properly classified as independent contractors or whether they should be employees. Something very important to keep in mind when considering this determination is that courts and agencies look at these determinations on using various factors, and they do it on their own factors that they set forth and their own guidelines. It's a misconception for an employer to believe that, or a company to believe that, an individual performing work for them is an independent contractor simply because they have an independent contractor agreement, or that they label someone as an independent contractor. The pure title of someone working for them, for an employer or for a company, does not mean that they are classified as an independent contractor. Courts and agencies look at all the circumstances and facts surrounding the working relationship to determine whether or not the individual was properly classified as an independent contractor. So when the issue of whether an independent contractor is properly classified comes about when there is a dispute as to the worker makes a claim that they are an employee and therefore they are entitled to minimum wage and they're entitled to overtime claims. We see that a lot when an individual claims that they are misproperly classified and that they are owed overtime or various wages from the company. Another situation where this is brought up is IRS audits of withholdings and unemployment agencies. Generally, an employer must withhold income tax, withhold and pay Social Security and Medicare taxes, and pay unemployment tax on wages paid to an employee. Employers or companies do not have to pay generally or withhold any taxes on payments to independent contractors. So you can see that this classification of an individual working as an independent contractor versus an employee makes a significant impact on the way that they are withheld for taxes and what the employer is obligated to do under withholdings or payment made to that individual. As I previously stated, all courts and agencies around the country set forth their own guidelines and standards for determining whether an individual is an independent contractor or employee. And we're going to look at today, just as an example, the Fourth Circuit test for determining whether an individual is an independent contractor or an employee in the context of a wage and hour claim. Again, this situation arises where there's an individual who has been identified as an independent contractor and is now claiming that they are an employee and therefore that they are entitled to FLSA requirements such as what we were just talking about for overtime and minimum wage. So under the Fourth Circuit's test, they look at various factors, and they have specifically stated that one is not determinative of this classification, and that in determining whether someone is an independent contractor, you must look at the entire situation and all of the factors in connection with each other. So let's go through these factors. The first factor that they have denoted is the degree of control that the company has over the manner of work that is performed by the individual or the worker. In looking at this factor, the questions that should be asked or considered are: who decides on the hours to be worked? Who's responsible for the quality of work? Does the worker work for any other companies? And who sets the pay? Looking at who makes these roles and these decisions can help identify whether there is the degree of control over the worker and whether that degree of control would indicate a employment relationship, not an independent contractor relationship. The next factor is the worker's opportunity for profit or loss based on his or her managerial skills. This involves questions looking at: did the worker make any investments, such as insurance or bonding? Can the worker earn a profit by performing the job more efficiently or exercising managerial skills, or to contrast, suffer a loss of capital investment? These types of questions help determine whether this independent contractor is in fact an independent contractor, or if it's not, whether it should be, again, identified as an employee. The third factor Fourth Circuit looks at is the worker's investment in materials or employment of other workers. So really you're looking to see whether this worker is reimbursed for any purchases or material supplies. You want to see whether the worker uses his or her own tools and equipment, whether they have their own employees that help assist them in their work, or whether they're using the employer's or the company's staff. The next factor is the degree of skill required for the work. This is pretty self-explanatory, but you want to look at whether the worker performs routine tasks for the company that requires little training, or whether it's a task that the independent contractor was specifically hired for and that they alone or with a significant degree of training can perform. The fifth factor relates to the permanency of the work relationship. Really, courts are looking at how long the relationship has been ongoing or intended to be ongoing for the worker and the company. Seeing that if it's an extremely long relationship and that the worker was only working for the company for an extended period of time and there's no site kind of ending, courts have looked at that in favor of an employee relationship. The last factor that the Fourth Circuit has designated is the degree to which the services are performed for the integral part of the business. This really looks at whether the worker plays an integral role in the business by performing the primary type of work that the employer performs for his customers or clients. And looking in it, you want to ask, does the worker perform a discrete job that is one part of the business or the overall process of production? And finally, you can look at whether the worker supervises any of the company's employees. Looking at these factors and seeing whether these services provided by the worker are an integral part or a significant part of the employee or the company's business will help identify whether they are an independent contractor or an employee. And that is the end of that topic, and we will now move on to the fifth and final question, and I'll hand it back to David.
Great. Well, thank you, Caitlin. So our last topic for today really concerns the question of, are my documents in order in terms of immigration compliance? And this has certainly been a hot topic lately as all the news reports out there indicate that there's been a significant jump in workplace enforcement activity by ICE over the past year or so. So generally speaking, what we're talking about here is the Form I-9, which is the document that has to be completed at the time any new employee is hired, and the purpose of which is to confirm that the individual being hired is eligible to work in the United States. And the form has two main parts. Part one is completed by the employee, where the employee fills in certain personal information, and then the form ultimately calls for an attestation that the employee is either a U.S. citizen, a non-citizen national, a lawful permanent resident, or what the form refers to as an alien authorized to work. Once the employee completes part one of the form, there's a part two. That part of the form is completed by the employer, and again, there are some boxes to be filled in, but the main component there is that the employer has to certify that it has reviewed documents confirming the individual's right to work in the U.S. And so in terms of what documents are reviewed, and once it's reviewed, the information's filled in on the form, there's two options. Either one document from what's called List A is sufficient, and the form outlines what documents fit within which category, but you can either have one document from List A, probably the most common example there would be a U.S. passport as well as a permanent resident card, or you would have both one from List B, like a driver's license, and one from List C. Probably, again, the most common one there would be a Social Security card. And so what I've got on this last slide is sort of an excerpt from an ICE publication that they put online just last year, sort of outlining a little bit of detail about what the potential penalties are in the event of an I-9 compliance violation. And as you can see, there are a number of factors that get looked at in determining what the penalty is for non-compliance. But one key thing to keep in mind is that even if all the employees are actually authorized to work and there's not a violation in terms of employing an unauthorized worker, you can still be exposed to fines if your paperwork isn't complete, or if you just haven't done I-9 forms for your employees. So one way to sort of get out in front of this concern is to perform a self-audit, which can be done in conjunction with legal counsel, to see whether the company's I-9 forms are compliant and how best to correct any deficiencies that may exist in the documentation. And I would certainly say it is important to coordinate that with counsel on that type of self-audit, so as to avoid inadvertently running afoul of, for instance, the anti-discrimination requirements when you're deciding how to conduct an audit, In other words, if you're sampling your employees and only pulling certain I-9s, you want to make sure that you're using criteria that wouldn't be viewed as discriminatory in how you do that, and also to make sure that if you're going and correcting certain deficiencies, that you're doing that in a manner that's consistent with what the government directs in terms of how that is done, so that you're not, essentially backdating documents or doing anything that the regulations direct you not to do. So that brings us to the end of our presentation today. I think we do have a few questions that we'll be happy to try to respond to here for anyone who would like to stay logged on and hear those. If you do log out now, let me just say thank you again for joining us today, and I hope you're able to take some information away from our session that will be of help to you in the new year.
Thank you, David. We're now going to begin answering questions that were submitted during today's presentation. As a reminder, you can still submit questions through the questions pane in your attendee control panel. So our first question is, are administrative assistants generally exempt?
Okay, so that's an interesting one, and the short answer to that question is the dreaded, it depends. There's actually a subsection of the regulations that comments on that and says that an administrative assistant for a senior executive at a large business would generally be considered exempt if that person's been delegated authority over significant matters and isn't just sort of following a preset list of procedures. And so again, assuming the person's paid on a salary basis in the required amount, sort of going back to the two-part test, the salary part and the duties part, assuming the salary is where it needs to be, really it would come down to a question of, what is the individual person doing? Are they exercising the kind of independent judgment on matters of significance that you would need to see in order to qualify under the test for the administrative exemption? So not every administrative assistant at every company will qualify. You will really need to look at the particular situation and the individual's, actual job duties.
And just to add a quick comment on that, and it's really important in addition to kind of focusing on the different tests and factors which you have to look at. Courts have specifically held that the job title or the name of the position does not independently identify or classify an employee as an exempt or non-exempt employee. So having a title of administrative assistant alone would not be sufficient to qualify under the administrative exemption. And as David was stating and how we stated earlier, it's really important to look at the different factors in the test for that specific exemption.
Great. Our next question is, if I have employees in Montgomery County, does the Montgomery County law or the Maryland law apply?
Okay, so I think that will be in reference to the paid sick leave laws. As I said earlier, Maryland had its paid sick leave law come online in 2018, and actually before that, where it started in this state was Montgomery County passed their own paid sick leave ordinance a couple years prior. And the Maryland law sort of tracks in a lot of ways the Montgomery County law in terms of some of the definitions, but there are distinctions there, and it's sort of a little bit unfortunate from the employer standpoint in terms of the level of complexity, but the Maryland law does not override the Montgomery County law. So if there are employees in Montgomery County, an employer would need to look at both the Maryland law and the Montgomery County law and make sure that they're tracking and complying with both of those statutes.
Very good. The next question I see, are the overtime rules still going to change?
Okay, so for that, anybody listening, you may have been following along back in 2016 when the Department of Labor came out with a new set of regulations that was going to update the exemption requirements for the FLSA. And the main way they were going to do that was to significantly increase the salary threshold that had to be met in order for an employee to be eligible for exempt status. And so there, If you recall, those came out. There was sort of a date that was set for when everybody had to comply, and then before that date arrived, there was a litigation where sort of a few industry groups filed a lawsuit alleging that the Department of Labor didn't have the authority to do that. And ultimately, there was a decision that put that all on hold. And then obviously we had the 2016 election, and since then it's kind of fallen off the radar screen. There have been word from the Department of Labor that they are now working on an updated set of new rules, and that's been delayed at least once. The latest that I saw was that in March of 2019 is when they've targeted to come out with the new proposed language. Now, once that actually comes out, it'll still need to go through sort of the rulemaking process where, you know, notice is given, comments come in, and then ultimately a final rule is published. So the short answer there is that the original new rules seem like they're, you know, just sort of in an indefinite holding pattern. It looks like we may get some new rules later this year, but at this point, we don't really have any indication of exactly what those are going to say, and we don't have an immediate timetable on that.
Great. Now that's the last question I'm seeing today. So thank you, David and Caitlin, and thank you everyone else for attending today's webinar, 5 questions employers should ask every year. If you have any other questions, please contact Whiteford, Taylor, and Preston. On behalf of Whiteford, Taylor, and Preston, and all of our presenters, thank you all for joining us today, and please have a great rest of your day.